Hi, my name is Chris. I'm a trainee solicitor at Arlingsworth. So the scope of who can petition the English court for a divorce is relatively wide. The position is governed by Section 5 of the Domicile and Matrimonial Proceedings Act 1973. Examples include, but are not limited to, examples such as the parties to the divorce being habitually resident in England and Wales, or the respondent is habitually resident in England and Wales, or the petitioner is habitually resident in England and Wales and has lived in the country for at least a year prior to the date of commencing divorce proceedings and filing the petition at court. So the meaning of habitual residence can be found in a variety of statutory provisions, and much guidance has also been offered by case law authorities, such as the 2010 case of ZZ and the 2007 case of Marinos. In MM, for example, Marinos, the petitioner was a Greek national. She became habitually resident in the UK the moment her plane landed in England, as she planned for England to be her permanent home. That was her main intention. So if it's not clear, the court will always look at the parties' circumstances and what their intention is exactly. In MM, it was held that the petitioner, Marinos, was entitled to petition for the divorce the next day after arriving in the UK. She landed at the airport and the next day she was entitled to petition the divorce. It should be noted that same-sex couples also are able to end their partnerships by way of dissolution. Dissolution is the equivalent of divorce for same-sex couples in a civil partnership. The statutory provisions found in the Civil Partnership Act 2004 effectively mirror those of the Matrimonial Causes Act 1973, which governs the provisions for divorce. So that's an overview really of who can divorce in the English courts. So same-sex couples can divorce, they can commence proceedings by way of seeking dissolution, which is the same thing. And also there is a requirement to show habitual residence in the UK.